Thank you guys for so much for joining us. I think we'll start the webinar. To preface this webinar, we see a lot of content from even our own side on things like investments, mutual funds, how to start saving, how to budget, how to do financial planning, how to save towards a goal, why invest here, why invest there. So we see a lot of these concepts on investments, financial planning, etc. Right? But estate planning is a very underappreciated and under talked about topic where the impact of this is majorly felt by your loved ones or your dependents only. So that is why this aspect is ignored by most people throughout their lifetime, and after their lifetime it falls onto their dependents to manage it and to run to courts, run to lawyers on how to get the assets sorted. Now, having a clear estate planning not only helps your loved ones, it helps you take stock of all the assets that you have, as well as allocate it to people or family members that you yourself want to, who have a better chance of taking care of those assets post our lifetime. Now, moving forward, let's see what estate planning is and how it can help a person. Estate planning is basically just organizing your assets and making sure that the distribution of them happens after your lifetime. Now, maybe you can think of it like this. Let's say I have some mutual funds or some shares that I want to bequeath, that I want to give it to my maybe my parents or maybe my children or my family or my cousins after my lifetime. Now, the nomination that is registered on the mutual fund or on the share or on the demat account is only the legal, is not the legal holder. It is only a custody of the assets. So, for example, let's say I'm putting my son as the nominee in the mutual fund. He's only a legal holder. If my will specifies that the mutual fund should go to my wife is the actual holder of the mutual fund. So even if my son gets it, he cannot do anything with it. He will be liable to pay it back to my spouse or his mother. So that is how an estate planning works. This is why estate planning is very important, because having a trust or having a will is not at all a very complicated process. It is in fact a very simple process. You have a lot of online tools nowadays to help you about. Now, the reason that we kind of do estate planning is to make sure that you are prepared for the worst. Because in worst of times, you never know, since life is so uncertain, we never know when life is going to end. So that is where kind of taking stock of your assets, making sure that we have everything ready. And a will is something that can be kind of amended as and when you go. It does not have to stay at the same place. So that is why doing investments is important. Yes, that is what we are all about here. But making sure that these are transferred to kind of your loved ones after your demise is equally important, because why do we do investments? We do investments so that our family is well, our kind of children are able to enjoy it. So all of this is only possible with the help of a good estate planning. So now moving on, let's look at some of the key components that I'll be talking about. A will and a trust. So these are one of the most important things about like an estate plan, because having these in place will ensure that there is at least a smooth transfer of assets. At least to some extent, the assets are smoothly transferred. Power of attorney. This is a very, very important thing where if you're not able to take decisions on your assets, or if you trust someone else to do it on your own, a power of attorney is a quick and easy way for them to do it. Advanced medical directive is because you see a lot of illnesses that are coming, you see a lot of paralysis, Alzheimer's, things like that, where you are not in control of your own self. So if you want to be in control of your own self, even after something like this, you have something like an advanced medical directive where you specify now when you're hale and healthy on what should be done if such a scenario does happen to you. So we'll be going through a lot of this in technical detail, but the main thing that you guys should be taking from this is very simple. Estate planning is there to help you transfer your assets smoothly towards your dependents. It is to make sure that you can avoid the family disputes that we often see in our own family, in my own family, in your own family, that happens when kind of these money matters and division of assets come into play. The first item that we'll be looking at that every one of us should have is a will. A will is a written document that specifies to whom which asset goes, in which proportion, when will they bequeath it, when can they start using it as well. So will is very, very important. Will is not only used for financial assets, it can be used for immovable assets. It can be also used for intangible assets, like if you have a patent, if you have a company. So all of this can be transferred via a will is equally important because you might want certain items to go to certain people and certain items to go to other people. Will is going to help you with it. Now, what happens if someone dies without a will? Now, we say the importance of a will. What happens if someone passes away without a will? That is when the process of intestate happens. Intestate is when you die without a will. It means that the legal order or the succession order of things will take place, and this is not a very easy thing to do. You'll have to get succession certificate, and your loved ones will have to go through a lot of court trauma to kind of get back the assets that you would have eventually transferred to them on your own itself. So a will is very, very important. You can name your children, you can name pretty much anyone in your will, and you can also specify executors as well. These are the people who will carry out what is in the will. So let's say something happens to you, you have a will in place, your will be proven in court. This process is called a probate. If you have a will, it's a registered will as well. This process becomes much simpler. This process gets over in maybe a week or two. And after that, a court will appoint the executor. The executor can be a beloved friend, a lawyer, maybe a professional kind of professional company. So all of these, there are companies that offer these services as well nowadays. So that person or that company or that friend will be tasked with partitioning the assets and making sure that all of these assets goes to the people that you specified. So that is why a will is very important. Do not wait until you write a will. A person can write a will as soon as they turn major, which is the age of 18. Now, why is this very, very important? This is especially important because when you kind of pass away without a will, you have $1.5 trillion of assets that is just sitting in unclaimed funds because there's some court dispute going on, there's some land dispute going on, because there isn't a proper kind of succession certificate in place. So all of these things has just resulted in these unclaimed assets just being there without anyone claiming it. So it is just an unclaimed account. The courts cannot transfer it. You have so many cases that's going on. So it's going to take multiple years for you even to see these assets. So that is why a will is very, very important. And you can always amend a will. A will does not have to be written only once. Let's say you're 25, you write a will, you're 35, you amend it with even more assets, you're 50, you amend it with even more assets. But you just have to make sure that you kind of keep amending it and keep updating your assets into it. So that is where a will comes into place. Now, probably a better version of a will is a trust. But that does not mean you should not have a will. You should still have a will and a trust in place. So that is the best point. So what is a trust? A trust basically avoids the whole court process. See, even if you have a will, you have to go through the probate process, which if you have a will is much simpler, but you still have to go through it. And then the court appoints an executor who will carry out the due diligence. Now with a trust, you transfer your assets when you are living into the trust. The trust has a trustee, and the trustee will take care of the assets for the benefit of the beneficiary. The beneficiary can be your family, can be your children, but the assets will be transferred into the trust. The trust can be the legal owner of the assets, and you can also specify that after a certain point in time, these assets will go to these beneficiaries or certain people as well. Now, you completely avoid the probate process, right? Because a trust is very, very private. It completely bypasses the entire probate process. It is its own entity. It will make sure that all of the assets all of the distribution from the assets go towards your children or your family members. This is very, very important, especially when you have children with maybe special needs or maybe relatives with special needs that you want to care for, where a trust will ensure that the trustee manages the assets as best as possible, and the beneficiary is still getting benefited by, let's say, whatever the distribution that these assets produce. You can specify 10 lakh a year, 20 lakh a year, maybe increasing. So whatever that is, you can specify this. But the special people do not have access to the assets, so the assets keep growing. They are managed better. At the same time, they get benefit out of it. Trusts are incredibly tax efficient because India does not have any inheritance taxes at this point, but who knows? This might be implemented in the future. This can minimize your estate and inheritance taxes greatly. Control over distribution. If you want to specify what percentage of your assets gets distributed and want to make sure that your trust simply kind of carries on without beneficiary or trustees mishandling it, you can specify that as well. So trust is incredibly efficient. If you have a trust and a will in place, that will kind of ensure that your loved ones are in place and the process is very, very smooth, especially in a country like India where there is a lot of bureaucratic kind of things involved before someone has access to your assets, and this process is usually slow. Trust and will greatly help you. They'll make your life 90% easier in these processes, where the rest 10% is basically going through the legal process to prove each of these things and get it over with. Going to the next point, just a small note on revocable versus irrevocable trust. So first we'll go into the revocable trust, where if the main thing about gifting things to a trust is that the trust has control over it. In the case of a revocable trust, these can be, you can kind of revoke the trust and you can take back the assets, you can add more assets, you can kind of terminate the trust after 5 years, after 10 years, whatever that is. And you can start a new trust. Basically, you have control over your assets whenever you need to. So estate tax. So for example, things like immovable property and stuff, the stamp duty is still there. So whenever you transfer it, the stamp duty will have to be paid. But one thing to note is that this is not protected from creditors, meaning if you go bankrupt, if there's some debt involved and some problem comes up in place, the creditors have access to all of your assets now. It does not stop with what is with you. It is also stops with what is in the revocable trust as well. To avoid this, you have a irrevocable trust where the creditors do not have access to it anymore. This is not flexible, meaning whatever assets that you put in, they are set. You cannot take them back. You cannot keep changing it. That is assets. So however what thing you want to go with, that is up to you. We just wanted to bring it to your notice so that there are different types of trust serving different purposes. So it is not a one size fits all. We can tailor it to your own needs. Now, coming to the next point, a power of attorney. Very simple thing. I want to give someone who has better knowledge of certain things and better knowledge of my preferences, a control of what I would do when I am of sound mind. Maybe in the future I am not of sound mind. Maybe in the future I have some certain illness that does not allow me to do it. So that is where a power of attorney comes in. Power of attorney is not only for investments. Yes, it is predominantly used for investments, but you do have medical power of attorneys in place. This is becoming commonplace in India nowadays, but this is very widespread in countries like Europe and America, where people have certain conditions where they do not want to be kept on a ventilator, or they do not want to be kept on a machine that keeps pumping their heart. They do not want to keep doing things like this, where in the case where maybe they just don't want to do it. Maybe they don't want to burden their family. So they give someone else other than their family the power of attorney or advanced medical directive, where they can take the decision of what to do on their behalf. Now, what are the types of power of attorney? A limited, where you tell them, okay, you're a power of attorney for the next 2 years for the purpose of managing my mutual fund investments. You have full POA to do it. General, you give them complete capacity, maybe a trusted family member or a trusted friend. Springing, this is what an advanced medical directive is, where after a certain, let's say 80% disability or 70% disability, this kind of comes into place. Medical, once you're incapacitated and not in the position to make a sound decision, a POA will carry out what you would have wanted to done when you have made the decision, when you were of sound mind. That is on power of medical power of attorney. Now, advanced medical directives is taking it one step forward. So God forbid, you're maybe paralyzed, or someone goes through an accident where they become kind of put in a place where they're not able to take decisions. First, a will can specify what needs to be done. A physician might say, okay, you might need to put yourself on ventilator for the next 5 to 6 years. Maybe we never know. Maybe there's some brain injury involved. So all of this is there, right? So that is why a medical POV gives you the kind of benefit of, let's say, if I'm going to be in this situation for a period of maybe a year or more, or if I'm put in the situation itself, you have the authority to kind of put me out of my misery. So to put it simply, that is what it is. That is what advanced medical directive is. So combining all of these, a will, a trust, and the advanced medical directive, just like you combine mutual funds, stocks, and a PMS, you have an array of things at your arsenal where after your demise, all of these will come to your support, where now your family members have been distributed their assets in the manner that you wanted to, because at the end of the day, you earned the assets and you have the right to distribute to them to whoever you want. And you also have advanced medical directive in place where we never know, right? When something happens, your will and your choice is still heard. Now, moving on to one single thing before I pass on to Vinayak, the power of an IPS. We all know an IPS as an investment policy statement, right? So you kind of outline your goals, outline your risk tolerances, and once you speak to an advisor, they kind of help you draw out an IPS to get to your financial goals. You can think of a will as the same way, where all of your assets are mapped to people that you want to give them to. And in the future, these are not unproductive assets, and these are still kept to use by the people that you want them to use. That's all an IPS is. A will is basically your IPS post-death. Now, I'd like to pass on to Vinayak, who will kind of take you through some examples, some case studies where we kind of talked about a lot of the fundamental aspects of these things. Let's see how these work in practice.
Yeah, so thank you, Nakul, for taking us through the brief and the key components of the estate planning and letting us know it's like what are the key things we need to consider. And it's like some things might go unnoticed, and it's like apart from will, trust, power of attorney, and advanced medical directives, there are other parts of the estate planning that we also should be aware of. And that's what I'm going to take you all through. To start with, about the capital gain tax on the inherited property. So actually, several countries such as USA, UK, Germany, and more have tax codes related to the inheritance assets. So however, regarding India, let us clear up a misconception that many people have. In our country, we do not have any inheritance tax as of now. And in fact, the law was abolished in 1985. Therefore, you do not have to worry about the inheritance tax while estate planning as of currently in the situation. But we are not sure. It's like the government is not going to go ahead and incorporate the inheritance tax again. So apart from that, let's say, for example, tax implication on inheritance assets would be whenever there is a situation of inheritance of an asset, relevant taxes may come into play under the income tax of 1961 and so. For instance, if person passes away, the property gets transferred to the legal heirs. Now, there can be a scenario where the property opens income streams for the new owners and in terms of interest or rent. In such instances, what happens is this income may add up to your, it's like the nominee or the legal heirs income and subject to income tax. So that would be the tax implication on inheritance tax assets as of now. And the owner of an inherited property is responsible to pay the tax at the appropriate rate on any capital gains that result from the sale of property also. However, under Section 54 of Income Tax Act provides a prospective exemption in the event that the earnings of sale are used to purchase a new residence or another property, or let's say, for example, we do have other tax saving assets like capital gain, saving bonds, and so on. And based on that, we'll also just see an example. So suppose you inherit a property worth 50 lakhs today, but it was purchased, let's say 20 years ago by, let's say, grandparents or so on, for at least for 10 lakhs and so. Then it's like, in our case, it's like using indexation, the effective cost of property could be higher, hence reducing the capital gains tax when you decide to sell it. So what happens is right now after the budget, it's like there is two options is, let's say whatever you had purchased before that budget date, you have two options. One is it's like you can use the indexation benefits, or one would be the lower tax rate on the long-term gains and so on. So that would be for the people who had purchased the property before this 2024-2023 timeline. And starting onwards, it's going to be a fixed it's like asset or capital rates for assets, equity, and everything so on. Apart from that, it's like there is something called as gifting provisions. It's like, and the exemptions under Section 56. So gift from relatives. So gift received from relative are exempt from tax. regardless of the value. Relatives include blood relations like parents, siblings, spouse, children, and others. So hence, apart from that, it's like, okay, again, gift to spouse or children. If you transfer assets to spouse or children, it may be exempt from tax depending upon the nature of asset. Apart from that, let's say, for example, if any monetary gifts are given to, let's say, family, friends, apart from someone like blood relatives, it's like above 50,000 of cash component, it's going to be subjected to tax. So hence, it's not something like while your lifetime, you can actually gift certain of your assets to your loved ones, so that it's like you can reduce the tax implications after your lifetime also. And there's also one thing that you can consider in your estate planning. So this is a very interesting component that actually I came across while reading about the estate planning and so. So one thing is, in today's digital age, estate planning isn't just about physical assets. Think about your emails, cloud storage, and even your YouTube account. These digital assets hold value, and it's essential to plan for their management even after you are gone. So hence, Google's inactive account manager is a tool that I found online, and it's designed to handle this. It allows you to designate a trusted contacts who will receive access to your selected data if your account remains inactive for a certain period of time. For instances, they may receive an email containing a list of data that you have shared with them, like your Gmail, Drive, YouTube, let's say bank account details, or let's say net banking passwords, and so on. So this feature ensures that your loved ones can access critical information, whether it's a financial record or sentimental data like photos and videos and so on. And setting this up is not only a practical but also a step towards complete transparency in your estate planning. So by integrating tools like this into your plan, you can protect your digital legacy and avoid complications for family in the future, because it's like taking control of your digital life today to secure your tomorrow is more essential. Because we have seen certain cases, it's like, let's say there is good component in FD, let's say for someone, but after their lifetime, it's like their dependents had to go in rounds with the banks to get it claimed because they are not aware about the net banking reset password or something in that case. So this is one interesting point that I found and I wanted to add is, it's like about the digital assets and including that in the estate planning. So one more thing would be, it's like estate planning isn't just about documentation. It's also about conversation that brings clarity and harmony to your family. Open communication is the key to reducing misunderstandings and ensuring it's like everyone is on the same page about it. So here are a few questions it's like to ponder on or to think about. It's like, what are your expectations for asset distribution? This helps actually aligning the family members' understanding of how assets should be divided and avoiding any potential disappointments on the later on timeline. And it's like, how do you feel about setting up a family trust? Trust can simplify management and production of assets, but it's essential to get everyone's perspective on this decision also. And apart from that, is there anything apart from this that worries you regarding a estate plan and so? So addressing these concerns upfront can eliminate uncertainties and make the process smoother for everyone involved actually. So by creating a neutral space for this conversation, perhaps would be a, let's say, a great thing, or let's say a guidance of a professional in this, like a financial planner or a lawyer, or let's say a family friend who can be a trustee or executor for you after your lifetime would be a very key feature for this. So it's like there are a lot of myths about estate planning. So one myth that I had, it's like before starting in the current financial planning and investments was, I do have nominees registered for my account. So would estate planning make sense? So I'll go from the myth 4 only. So it's like the nominees, as Nakul had mentioned, was they are only, it's like the people who will be trustee of your assets and they are not the owner of your assets. So owner of assets would be the legal heir as per your will, or in absence of that, like Hindu Succession Act or whatever the succession laws would come in. So nominees would not be the end beneficiaries, but they would be the trustees who would act on it, and it's like pass on the assets to your legal heirs in your absence. So the third myth that I had again was, it's like it's too young to think about estate planning. It's like, why should I consider that? It's like, one thing is, life is actually quite unpredictable, and hence it's like the earlier plan, the better it is. So having a plan in place is best thing, and you can do it for yourself and loved ones. So right now, it's like, let's say for a person who is in the age group of 20 to 25 or 30 also, they might think, okay, I have not built up any assets. Why should I have an estate plan? But one thing it's like I would say is right now, let's say I would not have a significant asset class, but let's say we have a term insurance component that we have. Let's say it might be of 50 lakhs or 1 crore term insurance cover and so on. And let's say, God forbid, if anything happens to the salaried person and the term insurance cover or the 50 lakhs or 1 crore is given to the family, and if they're not able to use it out and utilize in a better way, it's going to be a very bad situation for them, because it might be next 25 to 30 years they need to service from that corpus and so on. So hence, estate planning is important for everyone, if it is young or so, after the age of 18 for sure. And one thing that it's like estate planning is expensive. So in this case, one thing it's like I would say is to setting up a trust and will is not that a big job, or let's say a complex structure for sure, because let's say writing a will is very easy. As Nakul mentioned, there is a lot of online features. It's like you can directly go seek a legal advisor's help and set up a will. And trust also would cost, let's say 10 to 15K or so to starting out the process. There will be certain, let's say, starting out stamp duties and other works, but it's just a one-time cost to consider. Apart from that, estate planning is meant only for wealthy. One thing is, estate planning is essential for all, as per my understanding. It does not matter how much you own in your accounts or the number of valuations or the valuables you have. It's nothing but passing down your assets to the person you choose. That's the only thing about the estate planning that I would say. So again, as a recap about whatever we discussed, is like to wrap it up, estate planning is a vital for safeguarding and transferring your wealth effectively. We have discussed two key mechanisms that are wills and trust. A will is a straightforward document that outlines how your assets are distributed after your lifetime. It's not taxable, allows your asset modification through, let's say, court sales and so on. It's subject to contestation court by legal heirs. On the other hand, trust is more robust. It allows the settler to transfer assets to the beneficiaries only, either in a fixed or a discretionary manner. Unlike wills, asset removal isn't permitted, and dissolution often requires consent from all the beneficiaries. Trusts are less vulnerable for disputes, and as they cannot be easily challenged in a court. So choosing between a will or trust depends upon your goals and your family dynamics, whether it's simplicity, flexibility, or safeguarding against disputes. Both are important tools to ensure that your wealth transitions smoothly to your loved ones. Okay, so I'll say about one question that we come across a lot of time. Who can make a will and when? So will can be made by someone, as Nakul said, who is at 18 years of age, of sound mind, and free from any compulsion or any undue influences. And what are the circumstances someone should start thinking about a will? So one thing would be you started a new family, you are married, you are in a relationship, there's a situation of a divorce or a remarriage, or let's say, as we spoke about, is something like a terminal illness. These are the conditions that's like we need to consider. It's like will at the earliest phase of our life. And one thing would be, by adopting a trust route, a person can avoid the issues that arise in a will is for sure. Let's say it's like one thing is such as authenticity of the will or mental soundness of person making a will and so on can be completely avoided. It's like if there is a separate trust that is set up. So hence creating a private trust resolves most of these problems that are there in a will. So complementing both of it is very important. And hence it's like having a will and a trust is one thing that we would recommend you all. So it's like, as we spoke about the key components about will, trust, and so on, there should be continuous oversight of everyone. Let's say we mentioned as a tip, it's like you need to review your will on a regular basis. So that can be done with the help of financial advisor, your estate lawyer. So hence it's like whatever the change in complex of the family dynamics and so on, the financial goals would keep on changing. So these are the continuous oversight that should go on like an infinity loop with your estate lawyer, financial planner or advisor, or the trustee that you're going to be having to take care of your estate planning after your lifetime. So one thing would be, it's like, how can an advisor help you? It's like, obviously you're not alone. It's like we are there in this journey with you. We'll see it's like what is the family dynamics. It's like we'll help you prepare for this major life events, plan your retirement, family financial goals, and so on. Prioritize your aspirations, and most important is make smart investment decisions for you. And it's like this is one interesting checklist for estate planning that I found out. You actually can take out a screenshot of the same, and after the webinar we can also circulate it on our social media. So it's like this is a great flow for, or a checklist for the estate planning. like starting with setting up will, trust, designation of beneficiaries, healthcare documents, financial power of attorney, and everything. So you can just take a screenshot of this and you can refer it in your, let's say, later on when you decide on implementing the estate planning. So that would be from our end. We are open up for questions and yeah, happy to answer.
Guys, we opened up the chat and the Q&A boxes. If you have any questions, please do let us know in the comment section. It's a very important topic. It might not be very interesting, or it might not be very useful at this point in time, but it's a topic where you never know when its usefulness will come into effect. So please do let us know for any other questions that you guys have. Yes, sir, you are right. So the estate planning kind of remains the same, but each, if you're transferring an immovable property, each state has certain stamp duty in place, so it will differ from state to state. Correct. When is the right age to plan this? Sir, ideally, as soon as you have any assets in your name, you should be planning for this. Or if you have any dependents in a place where you want to transfer assets to them, you should be planning. There is no right age. Just like investments, starting as early as possible is the best way. Does ithought financial planning cover the will creation? No, so we do not have the expertise to do will creation and estate planning. We can advise you on it, but a lawyer or an estate planner would be the right person to do it. We can guide you on the financial plan on certain things that you should do, either a will, a trust, all these things we can help you with.
Also, we'll be able to put you guys in touch with a legal advisor if you don't have already any family advisor in legal cases and so on, so that they can help you out in the estate planning and the will drafting process. So it's like, is it possible to dissolve trust if taxation comes into picture in future? It's like, okay, dissolving the trust is possible. But one thing is, it's like you need to be aware of it. It's like that process is entirely very complex process. It's like there should be like agreement of all the beneficiaries. Unless that heads up is there's some legal compliance in that. After all the process, dissolving is possible. But it's like I would like to know. It's like why taxation, if comes into picture, is the thing. Is it about inheritance tax or it's just about the asset taxation you're mentioning? So in asset taxation, sir, it's actually more clear and easier because end of the day, even if you don't have a will or trust, due to interstate planning, it's like all the assets would be transferred to your legal heirs. At that time also, once the ownership is transferred to them, they are liable for the taxation on the assets because let's say whatever capital gains would come in or rental income would come in and so on. So that should not be actually a main factor to dissolve a trust and so on. So let's say, for example, if a purpose of a trust is fully fulfilled, let's say in one scenario, if someone has a special needs member in the family and for their care, it's like we wanted to take care and so on. At that time, it's let's say after certain stage, if that need is fulfilled, it's like dissolving a trust would make sense. But asset taxation is not one pain point that so you should consider for dissolving a trust. Will you help in writing will, forming a trust? So right now, so it's like we are not doing that process, but we'll be able to put you in touch with some of the legal advisors that we had worked with before for writing a will and setting up a trust, and we'll be able to sort it out for you.
Hello, Ramani sir. Good question. Is a will definitely required to pass on the wealth to legal heirs? Definitely, I would say not. But 100% this is required because we've seen processes even here where on death we do transmission of mutual fund units from one holder to another. And without something like a will or a legal certificate in place, it becomes very, very hard. A will has to be normally probated in court, which involves a lot of legal fees. Better to do settlement deed after discussion with legal heirs. Correct, sir. If the settlement deed is going to be simple and no legal heir are going to create any problems, then it's okay. But usually a will and a probate process, it does involve legal fees, but once you have a good will in place, usually the probate process gets done quickly, sir. So, but if you are confident of the settlement deed taking place, then I would say it is okay. Then whatever nominee that you give under a mutual fund or under a demat account, that would be the holder of the asset. We have nominees for mutual fund stocks through broking for estate family structure can be claimed. We still need will trust. Sir, if the person that you are giving the asset to is the same as the nominee of the mutual fund, as who is going to be the person that you're going to name in the will as well, then no problem, sir. But let's say if you're going to name me in the will and the nominee of the mutual fund is your wife, then I will be actually the owner of the asset. So that thing should be cleared up where will is the final document. And once that is probated in court, that is the only document that will be taken into place. Nominees for mutual funds and broking accounts will not be considered at that point. That is why we want to emphasize these nominees are only the custodian of the assets. The persons that are mentioned in the will are the legal owners. Will requires probation only in Chennai, Mumbai, and Kolkata. No, sir. Anywhere you do a will, you register it. You can register it, not register it. That's okay. Registration helps with authentication. That's all. It is not mandatory, but will requires probation in any court. So only when a will is kind of probated and the executor has been appointed, the will can be carried out. So one more question. Are Indian wills valid in courts out of India? Yes, sir, this is correct. But implementation of this is going to be very, very hard. This is also depend on if the country has good legal structures. And let's say if it's a developed country, in most places this would work. But of course, this is a very complex process. Will it be possible to share an individual cost sheet for making a will or creating a trust? Thanks a lot. Yeah, so that should not be a problem. If you guys do have any other questions, do drop them in the chat box. We're very happy to answer them. See, guys, just to preface, for most instances, having a will is helpful because one thing that we are very sure is that people change. And once people are in the kind of receipt of money, the money forces them to make certain decisions. So that is where if everything is clearly laid out in a will, then they do not have any power to take any decisions. That is why these things called will, trust, everything comes into play. So basically, to control human emotions is where these things are present.
It's like you can actually, it's like we'll reach out to you, and you can also drop it's like a mail to us. It's like we'll reach out to you and get in touch with the correct point of contact, and we can help you out in this case. So we'll also drop our email IDs in the chat box, and you can just drop us a gentle small mail, and we'll help you out in this case. So actually, it's like Nakul. It's like I would like to clear out any confusion. Is in the last sentence, it was actually correct. Will probation only requires to validate if the place was in Chennai, Mumbai, and Kolkata, because it's like there was some history because it was the colonial hub of British and so on. This was the only component, and hence that was mandatory. So that it's like if there's any assets involved with a bigger value or larger value, so the probation is the mandatory part there.
If you guys do have any other questions, do post them in the chat box. We're very happy to answer them.
So it's like there's one more FAQ that we generally come up with is it's like where it's like people ask about is registering a will mandatory. So in that case, what happens is it's like once you register a will with a registrar office and so on, the tampering of the same is very hard because then the trustee would be the registrar and hence it would be like much efficient. So registering a will is not mandatory, but like once you register it, tampering or let's say like any defraud or something would be very less the chances.
Can we go back to that slide?
Yeah. So we can keep the chat box open for another 2-3 minutes. So let's say whatever questions are there, you can let us know. Apart from that, like always any doubts and queries, you can always reach out to us. Yeah, so it's like that's what I said. It's like so you can just drop your mail ID or reach out to a team, and we'll help you out in it's like setting up a process and checking what best can be done in that same. So it's like I'll just drop our mail ID, Venkatesh sir, and based on that you can just it's like reach out to us and we'll do the needful.
Yeah, we've dropped our contacts in the box. That you're on mute. We've dropped our contacts in the box. You guys feel free to reach out to us, and thank you, Raja sir, for your kind words. If you guys do have any other topics that you want us to cover, like things like this where it often goes unaddressed, please let us know. We'll be very happy to research more on this and bring the content to you in a much simpler form. So thank you guys. Thank you guys so much for joining us. Hope you guys have a very nice weekend. Again, thank you for taking your time out on this wonderful Saturday morning. Hope you guys have a very pleasant weekend. See you guys soon for a very interesting webinar very soon. Thank you guys.
Thank you for joining the today's webinar.